just a couple minutes. We're waiting just a couple more minutes so everyone has the opportunity to join the webinar. Okay, looks like that's about it. Good afternoon. Welcome to the Texas Realtors Legal Webinar Series. This is our hot topics. This webinar will last about 1 hour, depending on how many questions you guys might have. The topic for today is the new Public Improvement District Notice. There is a new notice requirement, folks, and we're going to get This webinar is all about the new notice. My name is David Jones. I am Senior Associate Counsel with Texas Realtors. I'm part of the legal staff here. And I brought along a couple of friends who helped me kind of parse this out. I have Don Moore, President of Allegiance Title Company with offices in Houston and in various locations throughout North Texas. Thank you, Don.
Thank you.
And I have Tina Wilcher, licensed realtor, professional development director for Century 21 Exclusive Properties. She is a certified real estate instructor who teaches on behalf of Texas Realtors, HAR, NAR, Fidelity Title Group, Real Estate Business Institute, and many, many more. So thank you, Tina, for joining us.
My pleasure. Thank you for the invitation.
Okay, so briefly, we have a new law that was passed by our Texas legislature this past legislative session that made some significant changes to the Public Improvement District notice that is required. Beginning September 1, sellers will be required to provide a new notice to buyers when selling a property located in a public improvement district. This applies to sales contracts executed on or after September 1. It applies to all real estate transactions. Previous rule only applied to single family residential properties. It now applies to all. So new homes, condominiums, commercial, unimproved. If you're selling a property in a public improvement district, you have to give this notice. The new notice contains specific information about the PID, where the property is located. Buyers are required to sign the notice as evidence of receipt. And a separate copy of the notice will be executed by both the sellers and the buyers at closing. So we're going to get into detail in all of that. That's just sort of an executive summary of what the new requirements are. So let's start off with Tina. When I look at this, it reminds me of MUDs.
Yes.
Could you kind of go over the similarities between this notice and MUD notice? Because our members are familiar with MUDs. We've been doing that for a while. So could you kind of talk about, you know, a brief overview of what a MUD notice is and how this notice is similar to those?
Yes, David. It's interesting that I'm on this panel because I came from Milwaukee, Wisconsin, and we did not have MUDs in Milwaukee. So it was a new phenomenon for me to come to Texas and have to understand what MUDs are. And MUDs are municipal utility district and PIDs are public improvement districts, very similar in nature. And we're going to see more PIDs now that we have all these new construction and new developers coming in. And very similar to the MUD notice, you have to, as a seller, let someone know that there are assessments, because unfortunately when I moved here and I had a realtor, she told me nothing about it, and I got my tax bill and I'm like, what the heck is this $1,500 for, right? So it's really to make the buyers aware of what all they will be paying for. And similar to the MUD notice, they have to know where it's located. You don't have to give the amount. That's the cool and the different part as well, because in a MUD notice, you actually have to give the amount of the assessment of the bonds. But on a PID notice, you do not have to give the amounts. Also, on a MUD notice, you have to let them know if it's in an ETJ or an extraterritorial jurisdiction. That's also not required on this notice. I think that in looking at the PID notice, it's actually a little simpler to complete if you can find out if it's in a MUD and where that MUD is. It's a lot easier to complete versus a MUD notice. So the biggest thing for realtors is going to be making sure you can locate where to find out if it's in a PID and to find out what that county or municipality is that it's located in the PID. And then you'll talk about the 2 chapters of the notice as well.
And what about the penalties? What happens if a realtor does not?
Lots and lots of trouble on the seller's behalf, because it is the seller's responsibility to provide this notice and also prior to an executed contract. So that's going to be the big deal about it, is it has to be provided up front. It's something that really, when an agent puts a property in MLS, they should also include the PID notice in those notices and addendums that they provide. So it's very critical that they do this and that they locate it, because if not, it also gives the buyer another way to get out of the contract, right? And we want to eliminate as many ways to get out as possible. So it's going to help the seller, number one, to make sure that they provide the notification so that people are aware of it who's buying the property. And then also the buyer has to acknowledge receiving that. So it's going to be very critical that as an agent that we do our due diligence, just as we do with MUDs, to make sure that the seller is aware and they provide the information.
Thank you.
You're welcome.
Dawn, let's get a take from the title side, from the closing side, because again, these are very similar to MUDs. There are some differences that we're going to get into, but there is a requirement with MUDs that they be signed and executed by the parties at the closing. Is there something similar going on with the new PID requirement?
Yes, David, actually, these are, if you read the statute, they're very, very similar. And back to the penalties that just Tina was mentioning, technically it reads just like the MUDs. If you don't provide this notice on or before execution of a binding contract, then under the statute, the buyer has the right to terminate the contract for any reason or no reason after they receive notice. Then there is another requirement that we have to, as a title company at closing, provide the notice again. Both buyers and sellers sign the notice, and this notice has to be recorded. If the notice is given at closing and the buyer closes, then they waive any penalties or consequences that may have been for not giving notice. And of course, if they close, they can no longer terminate the contract. So actually, we've been dealing the same way with MUD as we will be dealing with PID. If you forget to have it signed or don't have the information by accident before you execute the contract, we will still have to do the notice at closing. And once they sign that notice and close, any of those consequences are waived by a buyer. So what we have seen is it reads exactly like the MUDs. Because this is new, people are a little bit concerned about the penalty. If we don't provide the notice, and I'll tell you where we'll find that, but if the title company doesn't provide the notice at closing and then the buyer closes never having received notice about the existence of the PID, there are significant penalties, including seller buy back the property. That's actually in the MUD, so don't panic. It's in the MUD notices as well. And I have never had any litigation from a buyer who doesn't receive the notice until closing. So treat it like the MUDs, and then be aware that it's here, and be aware that TREC has produced an addendum for you. And that's really to help direct you with the information that you need to fill out for your notice. However, the title companies will either have their own notice or they will pull it. The PIDs are now required under this statute to file a service plan. Within 7 days of creating the service plan, they have to, or being authorized by ordinance, they have to file the service plan in the county clerk records where the property is located, and this notice has to be filed with it. So we will pick it up from a title company standpoint in our legal examination of the property. This is when we'll pick this up, and we will use this notice to provide the notice at closing to get this information. Right now, where we, the title companies, get our MUD information, we get it off of our tax certificates, because PID, like MUD, is really a tax. It's a tax for a particular purpose. And so it's our taxing companies that provide the title company certificates at closing, so we can ensure no unpaid taxes, that we will find this information. And so it'll be similar to that. There was a little bit concern that this came so fast, and the PIDs don't have to file a service plan, another service plan. If they're already in existence, they don't have to file a new service plan for a year. And the current service plans don't have this notice as part of it. So where will we get this information? David can help you in a little bit, tell you where we get this information. We probably will get it from, again, our tax certificates, but we won't have those tax certificates until you've already got a contract and you've turned in that order for us. But we can look at CAD, and oftentimes we'll find it there. And then if they don't have the exact information we need, many of these public improvement districts will have a website that we can pull it from. So it's not something to panic about. We will have, we'll be doing this just like we do MUDs. You'll be doing this just like you do MUDs. And as Tina said, it's a little bit easier. You don't have to have the amounts on this notice for PIDs, but you have to direct them where they can get the amounts. And that will be on the PID. It'll be easier to do.
Yes. And one of the questions, David, is the difference between a MUD and a PID. You want to explain that to people?
Well, there are two different forms of special purpose districts that the state of Texas allows. There are a ton of them. There are lots and lots of different special purpose districts that are created by local governments, cities and counties for various purposes. A lot of them are, water districts, water control and improvement districts. The MUD. The MUD is one of the more popular ones because there's a notice requirement, but they are created as sort of small little jurisdictions where they're going to provide some type of service, some type of utility, or some type of service to a small little designated area in the city or the county, and then they get to charge a tax, an assessment, but it's only to property located within that little district. So they're all over the place, and there are many, many different types of special purpose districts within the state of Texas.
Yes. And I believe there's 957 MUDs.
Also, I see a few questions about the actual notice and where can you get it, and we are going to touch on all of that information in just a bit. Also, a bit of housekeeping I neglected to add at the beginning. If you have a question, please use the chat. Please use the Q&A function, not the chat function. We will be monitoring Q&A to answer questions. The chat, that is for the presenters to kind of, upload some documents that we're going to have for you in a bit. But please, if you have a question, use the Q&A function. Okay, now, Dawn, thank you very much for that, Dawn. Dawn did mention the PID notice and where it's going to come from. Let me back up just one topic, and that is the actual sales contracts. All the sales contracts had to be modified. There is currently a requirement for sellers, if you're selling a property that's located in a PID, a public improvement district, to require a notice be given to the buyer. The current notice is very generic, okay? And it's already included in, say, the 1-to-4 contract. It's in one of those flyover paragraphs that nobody really looks at. It's paragraph 6.
E7.
6E7. Actually, Now would be a good time to let me start sharing my screen so you guys can see. And we're going to share screen on some of this stuff. We've got kind of a show and tell where we're actually going to go through looking up PIDs in just a moment. Okay, on your screen, you see a draft of the 1 to 4 contract. This is page, where's the page number? Page 4 of 11. And you see, and this is the new notice. It's smaller, it's a shorter notice. This is not the PID notice that you're going to fill out. This is the notice within the sales contracts themselves. Okay, if the property is in a public improvement district, seller must give buyer written notice as required by the property code. An addendum containing the required notice shall be attached to this contract. That's the addendum we're going to get into detail. But that change has been made in all of the sales contracts. Both the TREC contracts and well as Texas Realtors, the contracts that we put out there, we just copied the exact same language. The new contracts will be available September 1. That is when the requirement for this PID notice is effective, September 1. It is for any contract that is entered, executed by the parties on or after September 1. So there's going to, there might be some tricky situations there because I know, the buyer might send the offer before September 1. If there's some negotiations that go back and forth and the seller has not signed it or has not been fully executed and you get to September 1, well, guess what? Now you got to use the new form. Okay. So there are going to be some tricky situations there where you got to be watchful of when the contract is actually executed by the parties. Anytime this month, you use the current versions that are out. September 1 going forward, you use the new versions of the contract. And the new versions, they will be out, okay? We're getting word from TREC that they're not going to be out with TREC until September 1. Okay, and we're going to put out our versions of the contract when TREC puts it out. So you might not see them until actually September 1, just to avoid any sort of confusion. If we put the contract out now and then people start signing it, it's not effective yet.
Can I chime in a little bit, David?
Yes, please.
And if you are currently have templates that are set up in Transaction Desk and Zip Forms and DocuSign, once the new notice goes into effect, the contract changes, then it will automatically update in your forms library. So you don't have to do anything for that. But if you have used this form in a transaction, do not copy it into another transaction. You want to, at that point, begin to use the new contract. So just know that if you have any templates set up, once it becomes available in the forms library, it will automatically update with the new contract.
Can I chime in, David? And I have a question more than an answer. What happens if I, on August 29th, I make my offer and we're negotiating it and it doesn't get signed until September 2nd? But I didn't even have the new contract till September 1. What is TREC saying we need to do?
Yeah, you're going to have to send over a new offer on the new contract.
So they're not going to give us an opportunity to use one to write on August 30th for a signing September 1.
Currently, that's not the information that we're getting from TREC. We're getting that it's going to be available September 1. If that changes, if they do put it out sooner than that, then we obviously will update our members.
Well, I can certainly understand the confusion, but I do worry about that situation where I've been negotiating a contract and it doesn't get signed until September 1. I have to change forms.
Yeah.
Yeah, we're going to have to keep a close eye on it.
Mm-hmm.
Okay.
And I think that it would be up to the agents to make sure that if it is located in a public improvement district, that the two agents have a conversation about it. That knowing that if we sign this, we will have to make a revision to this contract, and just let them know that that will be the only revision. Like, we're not going to change everything. We just want to revise that so that the buyers or the sellers don't get alarmed, but let them know why you're changing it and that this new rule went into effect and you want to protect everybody's rights.
That's right. Okay, let's jump into the actual notice. We've got a ton of questions on it and they are waiting. So let me switch over to the notice. Okay.
One of the questions that Ashley has is the seller doesn't provide it before an executed contract once delivered. How long does the buyer have to terminate after receipt? Forever.
Up to closing.
Up to closing. And once they close, it's assumed that they didn't require it.
Provided the notice is then given at closing too, but you can't terminate. But the penalty for not providing the notice at all, either at closing or beforehand, and they close, is a penalty where the seller has to buy back the property. So I guess you could call that termination of contract. That's the same penalty in the MUDs. So please don't worry about it. I've never seen it happen. And so I don't want anybody to panic, but that does read that way. So when I say you can't terminate a contract if you've already closed the contract, once you close, you've waived that right. But once we give the notice and they close, even though the notice is late, they waived all penalties.
Mm-hmm.
Okay, here we have up on your screen is the TREC version of this notice. And I say the TREC version because it is the districts themselves are going to put this notice out. Don went over that with their service plan. When they next update their service plan, the public improvement districts themselves have to provide a copy of this notice. Now, their notice is going to be nice and pretty and filled out with their specific information. But the broker lawyer committee at TREC has determined that they were going to promulgate this notice, and it is an addendum to the contract. But because it is an addendum, it's a promulgated form for every possible transaction. It's got a bunch of blank lines to fill in. So this form by TREC is actually one of the voluntary forms, so you can use this one, but you're not required to. You can use any of them that meet the statutory requirements. Like once the improvement districts actually do start putting out a copy of this notice, you can just grab that one and it's going to be the same thing. The language that you see here is mandated by the statute. So TREC didn't come up with this language. This language is already in the statute. So the public improvement district notice that they put out is going to be the same thing, including a place for the buyer to sign. I think broker lawyer added a place for the seller to sign on this one. That's not in the statutory requirements, but it is part of the statutory requirements for the buyer to sign this, that they have received this.
May I jump in here, David, a little bit, because I've already seen a couple of questions on this. The reason broker lawyer committee and TREC probably promulgated this addendum for you is because it's so new. I mean, we don't have the form. I know that we use the Texas Realtor MUD notice form, and it's not as an addendum to our contract, but it's just, this was their way of being sure that you gave the notice with all the statutory required information. But this is a voluntary form. Once the service plans are filed, more than likely we will pull copies of those and use those for the exact notices, and you can. So don't be misled if you get a transaction and your seller doesn't use this exact addendum for the notice, as long as the notice that they do use covers all of this information word for word, then that notice is sufficient. It doesn't have to be on this promulgated form. And broker lawyer committee hasn't usually put a voluntary form under their list of promulgated addendums before. And so I know it is going to cause some confusion, but it's extremely helpful as we start this new notice process.
Okay, got a question. The buyer chooses to terminate. Will the buyer's notice of termination have a line item to check, or would it be written in special modifications? It would be an other. Yeah, we have not heard anything from a broker lawyer that they plan on adding a special checkbox on the buyer's termination just for this.
If they did it for this, they'd have to do it for the MUDs.
It is Public Improvement District. Can a PID charge to get their form like MUDs can and do now? I do not believe so. I didn't see anything about that in the statutory requirements. PIDs are required to include the notice as part of their service plan, and their service plan is required to be publicly available on their website. But there's nothing in there about them being able to charge for it. Okay, let's keep moving. I know there's more questions, but I want to get to the juicy part here. And that is, how do you fill it out and where are you going to find all of this information? I will point out that there's sort of a gap here, because again, the improvement districts, they're going to put out a notice, their own, with everything filled out. They are not required to do that on September 1. It's the next time that they update their service plan is when that's going to happen. But sellers are required to provide this notice with the information filled out September 1. So there's going to be a gap that's going to require sellers, agents, brokers to go and search for this information. And where is this stuff? How can you find it? So I am going to turn it over to Tina, and she's going to walk us through some of this. I am going to switch my screen around and kind of show you in action what it looks like on how you can find this stuff. So Tina, if you could walk us through this form.
Yes, gladly. So very first thing, whenever you have a new form, you always want to make sure that you have the correct form number. So that's going to be at the bottom right. The date of use is always going to be, you'll see that. So this is check number 53-0. That's the form number. At the top right is going to be the date that it was implemented. So you will see that date change as well. So addendum concerning notice of obligation to pay improvement district assessment 2. And one of the biggest things on this form is locating the municipality or the county that is leveling the assessment. And the way that you can do that is if you go into realist text, a lot of times it has it under the jurisdiction. So you'd be able to find it. And David's going to show you some other ways as well. So it's in Texas concerning the following property, and then you would insert the property address here. So insert the full property address. As you go through, it reads, as the purchaser of the real property described above, you are obligated to pay assessments too. And again, here's where you're going to put that municipality or the county that is making the assessment. In Texas, for the cost of a portion of a public improvement or service project, which is the authorized improvements undertaken for the benefit of the property within the. And then here's where you're going to name the PID, okay? So here's where you're going to put the name of the PID or the Public Improvement District. And again, you'll be able to find that in a lot of cases in your tax or your CAD, or like we have realist tax here in Houston, and we can put the district there. And one of the things that that agents may stumble upon, and David's going to go over this, is which chapter do you use? Because you have to insert, is it in chapter 372 or is it in chapter 382? David, you want to explain the difference in those here?
Sure thing. Yeah, this looks scary, folks. It's really not. We've done a lot of research on this to kind of narrow it down. This form requires, sellers and agents to know the local government code and which chapter under the local government code that this particular PID was created under. It sounds daunting, but here's the thing. Chapter 372 of the local government code, that is the main chapter that gives local governments, we're talking cities and counties, the authority to create a public improvement district. That's the main one, 372. 2009, a portion of 372 got pulled out and got its own number. And that number is chapter 382. So that's why there's two different chapters. 382 is very limited in scope. Okay, 372 is the main one for all of Texas. All the cities and all the counties can use 372. 382 is very limited. And when you kind of break it all down, it's limited to 2 counties, not cities, just the counties. 2 counties in the state of Texas: Bexar County, which covers San Antonio, and Comal County, which covers New Braunfels. That's it. Those are the only 2 counties in Texas that can possibly use 382 of the local government code. And when digging a little bit further, this is a memo that Texas Realtors has put out. I will drop, if you haven't received this, we've already sent it out through our focus and other email communications. I will drop this in the chat for everyone here. But we're looking at this paragraph here. Currently, Comal County does not have any PIDs. They can in the future, so you still have to, be on the lookout for them, but currently Comal County has none. Bexar County has 3. Okay, and I've put them in here. Cibolo Canyon Special Improvement District, Crosswinds at South Lake Special Improvement District, and Westside 211 Special Improvement District. That's it, folks. Those 3 PIDs in all the state of Texas use chapter 382. Okay, it's that limited. Any other city or any other county, if you're in those counties, if the property that you're dealing with is anywhere else, they are using chapter 372.
Very good. That's easy, right? I can't hear you all, but I know you're thinking. Nah. But in all actuality, that's what makes it a lot easier, because in a municipal utility district, you have to go back and figure all that stuff out. On this one, David, thank you for that. You've made it very simple with only having 3 that fit the description of 382. Also, this takes us back to geographical competence. It means that you need to be working in an area where you're familiar with these things. And that's something that TREC has really been honing in on, is us being familiar with the area and the areas that we work in. So geographical competence is going to be important when understanding PIDs and MUDs. Okay, thank you for that, David. Moving forward, so you do have to insert subchapter A, chapter 372, local government code, all 3 of those, that entire phrase, or chapter 382, local government code. So make sure that you're familiar with which, and David has given us an easy to follow example. And then the paragraph reads, an assessment has been levied against your property for the authorized improvements, which may be paid in full at any time. If the assessment is not paid in full, it will be due and payable in annual installments that will vary from year to year, depending on the amount of the interest paid, collection costs, administrative costs, and delinquency costs. The exact amount of the assessment may be obtained from, and again, you have your municipality or your county, you're going to put that in. The exact amount of each annual installment will be approved each year by, and again, you're going to insert the city council or the county commission's court for the county that it is located in. in the annual service plan update for the district. So you heard Dawn mention quite a bit that the annual service plans are not due at the same time for every PID. It varies. So even though we have this rule in effect that takes place on September 1st, some annual plans have already been done and submitted for the year. So some of them you may not even see until next year. More information about the assessments, including the amounts and due dates, may be obtained from, and again, you have your municipality and your county, you would insert that. Your failure to pay any assessment or any annual installment may result in penalties and the interest being added to what you owe, or in a lien on and the foreclosure of your property. So someone wanted to know the repercussions for it. If the buyer does not pay it, they can get a lien on the property, or the property can be foreclosed. It's not optional. And please let your buyers know who are coming from other states about a PID, about a MUD, about HOAs, because these are things that they may not be familiar with and where they're coming from. And then you have the seller's signature and date. And keep in mind again that on the service plan documents, it may not have a location for that. This is something again that was added into the TREC document. And it says the undersigned purchaser acknowledges receipt of this notice before the effective date of a binding contract for the purchase of the real property at the address described above. And then you're going to have the buyers to sign. So as I mentioned, it's very important if you're the listing agent to put this document in your MLS documents, because the notice clearly says that it needs to be provided prior to the execution of a binding contract.
Thank you so much for that, Tina. Let me go over a couple of questions because there are a few good ones. One talks about, do you have to add this? Will the notice provided by the PID a notice or an addendum, and the PID notice, will it or will it not be included in the addendum section of the contract? Let me switch back over to, this is the draft version of the 1 to 4. And again, all the other sales contracts are going to have this language as well. Look at the blue line here. An addendum containing the required notice shall be attached to the contract. That is the language that was added. So yes, it is a requirement because of that language that an addendum be added to the contract that is this notice. Yes, it's a notice under the law, but it's an addendum because of this line. So this line makes it mandatory that you attach an addendum. The second part of that is, what do you check in the addendum section of the contract? So forgive my screw. Yes.
David, if you don't mind, because it relates to that, but it also relates to the question that we're saying you have to use this contract. If you look at the date in the top right corner, the contract really isn't even promulgated yet. It's 11/8/2021. So we're saying we have to use this contract because it's been approved for our use, but it's available for comment. And I'm going to ask that question. It comes to that question. Does it? I mean, I thought it was a very good question. I think it was April that you brought up. Should this be a notice or should this be addendum? Because if we're saying it's like MUD is a notice. And I think the PID service plan, but I don't know, we haven't seen them yet. This is new for the PIDs too. Their service plan will just refer to it as a notice. They won't title it as an addendum. So I don't know how that will come out. I think you have time to make comment to broker lawyer, not to the commission, about whether this should be an addendum to the contract or just a notice like we handle the MUD notice. If we feel like it needs to be an addendum, then do we need to add in paragraph 22 an addendum containing notices about the MUDs? Those are things that you should take back to your offices and start talking to it, because you do have time to make comment to this contract. But for the time being, because of this emergency, you're going to have to use this contract starting September 1.
That is an excellent point, Dawn. Thank you for that. Yeah, this, and she is absolutely right. Up here at the top, excuse my scrolling, everybody. Up here at the top right corner, you do see that, November 8th date. this form has been approved for emergency use basically, so that it is in compliance September 1, but they are concurrently doing their normal new promulgated form process, which you guys will absolutely have a right to make comments, and TREC will look at those, broker lawyer will look at those, and they will take that up at the November 8th meeting. That is the next TREC meeting. That's why that date is up there. So yes, send in your comments.
One of the questions, let's see if I can find that. Someone asked a question that I wanted to answer. I'll find it and then come back to it.
Well, and David, I didn't mean to get you off track because you're on a very important point, so I apologize. But I do want to answer one other question that someone brought up. You guys have got really good comments. What will the seller's disclosure notice be amended to have this disclosure that the seller has a disclosure in that, like I guess for the MUDs? That seller's disclosure notice is actually prepared by your own group, Texas Realtors. So that's something you guys should discuss. And if that's something that you feel would be great for a seller to disclose up front in the seller's disclosure notice, do it. But that doesn't replace the notice that you have to give on the statutory format that you have. Someone else asked in the statutory format that, David, that you just went by, why don't they just have a box to check? It's either chapter 372 or chapter 382. As David said, this literally follows the statute. And so we didn't veer from that at all at this point. So that's why it doesn't have a box to check. It does sound easy, but they don't make it easy for us.
Yes. And another question that someone had was, is it the agent's responsibility or is it the seller's responsibility to fill this out? And it is the seller's responsibility, but we know as agents that it's something that we do. So just as with the MUD notice, most sellers don't even know how to find that information and they just pay their taxes. They don't even recognize that to be a part of the jurisdiction on their tax statements. So it is going to really fall on the agent's shoulder to do your due diligence to locate if a property is in a MUD or if it's in a PID, and for you to fill the notice out, let your seller make your seller aware of the notice and then provide it, right? And I like that they have a seller signature because that's you doing your due diligence and serving your client by finding this information out so that they don't omit to share it. So it is the seller's responsibility, but we help them with their responsibilities, if that answers your question.
Okay, let's see. Looks like Conan asked a great question. Is there a simple way to determine if a property is in a PID in case the seller doesn't realize it? Well, if I delete the word simple, then I'll say yes. There is a way. I can't promise you that it is that simple. You know what, let's jump into that now. Let me switch my screens around here. Do you guys all see that now? The switch over, this is the Travis County Appraisal Districts. Tina mentioned that it's also going to be in your MLS. Your MLS pulls the tax records from the appraisal districts. So you can either go to your MLS. I don't have access to that right here, but this is a appraisal district website that I can search publicly. So this is the property search function, and that's usually how you guys are going to be looking, right? You got a listing agreement. You want to know this property. I got the address. How do I see if my property is in a PID? So I will search. This is a random. Hang on. Oh, technology always works when you're testing it, but then when you actually got to use it, then it doesn't work. Hang on. There we go. Let me find a couple. 700 East. So this is random property in downtown Austin. Taxing jurisdiction here, and this is going to be something similar to what you'll find on your MLS. And these are the taxing jurisdiction, the taxing units that are providing some type of property tax. I picked this because I know for a fact there is a PID in downtown Austin. And if you look right here, it's abbreviated, but that is the name of the public improvement district here in downtown Austin. Very creative downtown public improvement district. Okay, so that's how you can find the name of a public improvement district. And the reason why I say I can't say it's, you know, a simple way, this is a good way to start. It's not a foolproof way. We have heard that, especially with either a newly created PID or, you know, new home construction, if there's a PID there, there's like a lag time between when the PID is created and when it's going to show up on appraisal district, county, city websites. There's a lag there. So you might have to get creative. You might have to do some more digging. You know, the information is out there. It might require you a little bit of work if it's a brand new PID. Now this one, someone says the tax rate is 0. That's just this PID. It's not always going to show that. That's just that's this one. But what's interesting is the form does not require any of that other tax rate information. The form is actually fairly simple to fill out because most of those lines are just repetitive. Here, let me bring it back up real quick. Most of these lines, like the property address, obviously you're going to have that. We went over chapter 372 and 382. If you're not in Bexar County in one of those 3 PIDs, you're going to write 372. So all you really need to find is the name of the PID and was it the city or the county that created it? The city or the county gets filled in like 5 or 6 times on this form. So there's really only 3 or 4 pieces of information you really need to have to dig and find.
Right. And one of the things that was a question, it has insert name of city council or county commissions court. That's not a hard one because if it's Missouri City, then it would be Missouri City Council. If it's Fort Bend County, it would be Fort Bend County Commissions Court. So you can basically just take that city or court and find that city or county and find the name of the city council or the county commissions court. It usually follows in line with the name of the city or the county.
Okay, so let's continue. So let's say that's the first stop. Let's say it's one of the easier ones and it's an existing PID. It's been there for a while and it's in the appraisal district's tax records. You see it. What's the next step for the other information? I've tested this on several different appraisal district websites. Some of them will actually have a link, this where it says the name, that will be a link that will take you. This one does not, but a simple Google search. Again, this is the part where it might take a little bit of digging and why it's not always so simple. But if you type in the name of the PID, it will take you to their website. All the PIDs are required by statute, by Texas law, are required to have all this information on a website, or at least have a link to where you can find all this stuff. The appraisal districts, there is also a statutory requirement that says they have to list all the taxing units. Any special district that is levying some types of tax against that property, the appraisal district needs to have that listed. Again, there's that delay if it's new, but there is a law that says appraisal districts have to keep this information. So if we were looking up this PID and you were looking for, okay, what's the city, what's the county? It's on this very first page. You might have to read a couple paragraphs in. But here, first authorized in May 1993, Austin City Council. Okay, this PID is the city of Austin. That provides you with all the information you need to fill out the form. You're going to have the address, okay? We now know that it's the Austin City Council. So you just put in City of Austin, City of Austin, City of Austin's all over the place. And that service plan that we were talking about before, that needs to be publicly available. And here's a link to it. It's that last blue line. Now, this is probably going to give you more information that you want to know, but it's there. All of this stuff is online, publicly available. Sometimes some might take a little bit more digging than others, but it's all there.
Yes.
So here's the service plan for the downtown Austin Public Improvement District.
So I think the lesson here and to remember is that you may have to go outside of your MLS. I know a lot of agents are used to finding everything they need in the MLS, but you may have to dig a little deeper and go into your city and county websites to get this information.
And someone asked me if it doesn't show up on our tax certificate, or if it doesn't show up under CAD, will we find it from our tax certificate? Likelihood, if it doesn't show up on CAD, it probably is not even going to show up on our tax certificate. But when we do a title search, that remember, they're supposed to file that service plan within the county, in the county clerk's office where the property is located. We should pick it up there. The notice, though, may not be on that current service plan. We pick up PIDs now. It may not be on that service plan yet. So we'll have to then reach out and go to the website and get this information on that PID as we develop this, if it's not shown, but yet we file it on our title book.
Okay, couple of questions someone asked for. The example that I just pulled up, is that Travis County or Austin? That is the City of Austin.
And just as David pulled it up, it said the City of Austin. So make sure you use exactly what it says, the City of Austin.
Someone did ask more clarifying comments about the September 1 versus the 11/08 line. The statute that requires this is effective September 1. Okay, so sellers are going to have to provide this notice to buyers if their property is in a PID. They have to provide this notice for contracts executed on or after September 1. And what TREC did was, because they didn't have the time to go through their normal process of promulgating a new form, they approved it for emergency use effective 9/1. So you can use it September 1 so that you can be, or sellers can be in compliance with the statute come September 1st. But they are also doing their normal promulgated form procedures. Okay. And so under those normal procedures, they will not be able to officially approve the form until their next TREC meeting, which will be November 8th. So that's why there's 2 dates. So yes, you absolutely can and need to use the new form 9/1, September 1. Someone asked the memo that Texas Realtors has put out. I did put it into the chat. I think someone was speaking. I didn't want to interrupt them, but I will throw it in there again. Okay, if you check your chat, you can download the memo.
And one of the questions, David, was if a buyer receives the notice, signs for it, and they receive it even after the contract has been executed. Once they receive it, acknowledge that they have received it, they cannot terminate for that reason.
That's incorrect.
What is the correct? That's what they want to know.
Yeah, the statement in the property code, and I'll read it exactly what it says. In the event a contract of purchase and sale is entered into without the seller providing the notice, the purchaser is entitled to terminate the contract. That's it. There's no further language that says that the buyer's got 7 days, or if the buyer signs something acknowledging. There's none of that. It's if the notice is not provided before you execute the contract, that the buyer has the right to terminate, period. And that's the same language with the mud notice, by the way.
There was one question, I know we're getting over time, but whether this PID notice has to be sent in every type of transaction. It does have, and you specifically asked, kind of the exclusions that the same thing like a seller's disclosure notice has, that if it's a bank who foreclosed on the property to another person, there's certain categories that you don't have to provide this notice if you're selling from one spouse to the other spouse or family in the first line continuity. It's listed in the statute. Always to be on the safe side, disclose, disclose, disclose. But there are those categories, kind of like your seller's disclosure notice, where you may be exempt from having to provide it.
Okay, folks, I see our legal administrative assistant, Chelsea. She put the memo up there. Did everybody get that? I guess mine didn't show up. There we go. And again, the memo is on our website. We've sent out blogs, we sent out emails. I will add, it's almost time. I want to thank our two guests, Tina Wilcher and Don Moore. Thank you, thank you, thank you so much for help with this. It was great getting the insight from two experts. Thank you.
Thank you for the invitation.
Thank you.
And as a final note, if you still have questions about this, we do have the legal hotline available for members. Let me see if I can remember it off the top of my head. It's 800-873-9155. There. Nope, that didn't work. Just putting it in the chat so it will be there for our recordings as well. There we go. Okay, any questions you have, if we didn't get to them, I apologize. Give the legal hotline a call, and thank you for attending the Texas Realtors Legal Webinar Series. Thank you, everyone.
Thank you.